In her defense, the victims aren't here either, and we don't anticipate them ever showing up.
You said in her defense, the victims aren't here. And what happened?
We don't anticipate they're gonna show up.
Is that accurate?
The victim is not here, Your Honor, and I have not had contact with.
You've never had contact with the victim?
Double check. Victim just went down. I don't know if we are.
I feel like magistrate numbers. And write it down. It works. Let's see.
It seems the only number we have on record that has restrictions and it cannot be completed as that. So that would be a no.
Oh, sounds like you all should send a letter. By the time the bench warrant gets out there, maybe that letter will catch up. Then everybody can come in and have a party in courtroom floor. Thank you.
Thank you.
And Johnson. And Menzies.
He's here. His attorney is out in the hallway speaking with him right now, Your Honor.
Are you ready on Braxton?
We are ready to go on for action.
On the record in the matter of the people of the state of Michigan versus Dalrico Braxton, file number 23-00384FY, council appearance.
Brian Ring on behalf of Keel practicing under Michigan Court Rule 8.120.
Thank you, Honor. Jeff Culture, appearing on behalf of Mr. Braxton, standing immediately to my right.
Okay, today was the date that we reset the preliminary examination. Discovery was still pending back on February 16th. There's a request to adjourn today. Is that correct?
There is, Your Honor. I had spoken to the officer, the lead officer on this matter, and he was unavailable today due to a mandatory training that he could not get out of, Your Honor.
Okay, I'll reset this matter.
March 31st.
March 31st, okay? March 31st at 9 a.m. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Your Honor, I'd move for dismissal of the record. For here.
Motion
They can
is
always
denied. There
refile.
was a mandatory training, which is outside of that officer's control. So the motion is denied, but it's on the record. Thank you.
Mr. Braxton, hold on.
Mr. Goodrich, do you have Mr. Searcy here?
Yes, he's sitting right next to me.
Are we ready on Mr. Searcy? Mr. Ray?
Mr. Searcy, can you give me a nod on that one? Mr. Searcy's gonna be a nod, Your Honor.
Okay, so do you have Mr. Black here?
Black is here.
Your Honor, Mr. Black is ready to proceed, and that matter is going to be a
Thank you. Is he ready?
just signing the advice of rights form right now. You're all set.
On the record in the matter of the people of the state of Michigan versus Derek Black, file number 23-00550 FY, council appearance.
Brian Ring on behalf of the people practicing under Michigan Code 8.120.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Black, who's standing to my right.
How are you, Mr. Black?
I'm fine.
Okay, are you hot?
Yeah,
We need to get a little air in here, huh?
how you doing?
I'm pretty good. We get a little air in here, Mr. Black is hot. Okay. Mr. Black, today's the date that's set for your preliminary examination. I have a plea offer here. Says the people are offering for you to plead guilty to an added count 3 of use of a controlled substance under MCL 333.746642B. It's a misdemeanor, maximum penalty 1 year and or $1,000. There is no objection to sentencing under 7411 if eligible, and they will dismiss counts 1 and count 2. Did you consider that offer?
Yes.
How long did you consider that offer?
I was told about it a couple of days ago that might be part of the agreement.
Okay, so you want to accept that offer today?
Yes, ma'am.
Oh,
Your Honor.
I have an advice of rights, complete information sheet on it. What's today's date on it? That's your signature?
Yeah, sorry, I couldn't.
No, no worries. Just want to make sure you did that, right?
Yes,
And you
ma'am.
read this document before you did that?
Skimmed through it. I was told that it was a 7411 agreement and, no,
These are the rights.
The rights.
The rights that we talked about.
oh, the advice of rights. I'm
Yeah,
sorry.
there's no such thing as a 7411 agreement.
Yeah.
These are the rights that you have to waive in order to accept.
Oh, the right to trial.
Yeah, this is the most important part.
I understand that.
Is you gotta give up these rights if you want to plead. You understand that?
Yes.
So that means you're gonna give up your right to the presumption of innocence. So do you understand that you're innocent until they can prove you guilty?
Mhm.
Is that a yes?
Yes, ma'am. I'm
Okay,
sorry.
you want to give up that right to the presumption of innocence today?
Yes, for the use charge or possession charge.
Okay, and you also understand that you're gonna give up your right to see, hear, or question any other witnesses that the prosecution intends to call at a trial?
Yes.
You're gonna give your right to call your own witnesses or present evidence that you believe would further a defense to the charge?
Yes.
Okay, you're gonna give up your right to have a trial. That means a jury trial, and that means you're giving up the right to have the prosecution have to prove each element of the charge being brought against you, and they have to prove it beyond a reasonable doubt at trial. You understand that?
I understand.
And you want to give up that right as well?
Yes, Your Honor.
Anybody threatening you to give you to waive your rights today? Any promises being made to you to entice you to want to waive your rights?
No.
Are you currently on probation, parole, or on bond or any other matter? Do you understand that a guilty plea can result in a conviction, which you may need to report to your current job?
No, yeah, I understand that.
Guilty plea can also result in a conviction that you may need to put on a future job application. It also could have impact on any immigration or travel status you may be seeking. So you may want to go up to Canada for the weekend. You understand that this could have an impact on that?
Yes, Your Honor.
Okay, you still want to waive your rights, understanding that?
Yes, Your Honor, due to the upon my arrest, I know what happened.
Okay, we're gonna talk about that in just a moment. Are you entering a guilty plea because you believe you're guilty?
Of the possession, yes, ma'am. Your Honor.
So the offer is for you to plead to an added count 3 of use. You understand that?
Yes, Your Honor.
Not of possession. Okay, you're entering a plea because you believe you're guilty?
Yes, Your Honor.
Okay, as to the added count 3 of use of a controlled substance, how do you plead?
Guilty.
Can I have a factual basis, please?
Your Honor. Mr. Black, on or about February 18th of 2023, were you at a location near Hill Street?
Yes.
And is that in the city of Lansing, county of Hingham, state of Michigan?
Yes.
And you actually came into contact with the police at a gas station, right?
Yes.
And at that time, were you in possession? Yeah, I know we were planning to plead to the factual basis of the underlying offense in this matter. Were you in possession of a mixture containing the substance of cocaine?
Yes.
And where was that cocaine found?
My left pocket.
Okay, so you were in possession of that cocaine,
Yes,
and you didn't have any legal right to be in possession of cocaine at that time, correct?
no,
Your Honor, I believe we have a factual basis to the underlying count of possession of this controlled substance.
Any questions, Mr. Ring?
Just one. And Mr. Black, you knew that substance to be cocaine.
I don't wanna, get too far out of the lines, but that's what it said, it was to be, under the other charge. Yes, I did.
Sure you knew?
Yeah,
No further questions.
Okay.
Sir, did you know it was some type of illegal substance? Even if you didn't know specifically which?
yeah, in
which
the,
one?
in the midst of the occurrence with the other person,
And it was in a baggie that is commonly
yeah,
used to contain illegal drugs?
yes,
Oh. Court is satisfied with the factual basis. I'll accept your plea. I find your plea be made freely, voluntarily, and intelligently. This matter will be set for sentencing. The sentencing is going to be on May 5th. No, it's not. I don't think I have a wedding to attend any. Date.
Probation.
excuse me. Well, I didn't know that the city. Oh, okay, sorry.
We're gonna get a different date.
I'm sorry.
May 11th.
You said May 11th. At what time? May 11th at 8:30. You can appear via Zoom for that if you'd like, as long as you have video and you're in a place appropriate for court proceedings, okay?
It's gonna be on video, you said?
You can appear via video.
All right,
You just need to have video capabilities, and you need to be in, you can't be driving, you can't be in a loud location, that sort of stuff, okay?
I understand.
Okay, and that blue sheet is the instructions about how you log in via video. And then when you leave this room, you're gonna go downstairs to the 5th floor. You're gonna meet with probation so they can get you set up with the pre-sentence investigation, okay? They're gonna provide the court with a report about how they believe you should be sentenced and whether or not you're eligible for status under 7411, okay? Do you have any questions today?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
No, Your Honor.
Mr. Black? On the record in the matter, the people of the state of Michigan versus Davon Delonte Searcy. File number is 22-03415. FY council appearance.
Ryan Ring on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Cersey, who is standing to my right.
How are you, Mr. Searcy? Today's the date that was set. For preliminary examination. Who is the prosecuting official that signed this?
Jennifer Lott.
You said Lawton, LAW.
LAWP.
Today was the date set for your preliminary examination. However, the necessary witnesses have failed to appear. And so the prosecution is unable to proceed at this time. They're making a motion to dismiss this case without prejudice, and they are objecting to the destruction of the arrest records under MCL 764.26A. Do you understand what that means for you, sir?
Yes.
Okay, do you have any questions about your rights at this time? Okay, so the case will be dismissed without prejudice. They do have the right to reissue if the charge or if the witness makes contact with them and is ready to proceed. Any additional matters for the record today, council?
Nothing on behalf of people. Thank you, Your Honor.
No, Your Honor, thank you.
Please give us 72 hours to remove any no contact orders that's in lien, okay?
Okay.
Okay, you're all set. We'll get you a copy of that.
Thank
No problem. We ready on Menzies? On the record in the matter of the people of the state of Michigan versus Adam Charles Menzies, the file number is 23-00091 FY. Council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Christina Costantino, P 79668, appearing with and on behalf of Mr. Adam Menzies, who is present in your courtroom and standing to my right.
And today's the date set for a preliminary examination and a hearing on the PA 53 violation. You have a victim here?
I do, Your Honor.
My understanding is that there is a waiver of the exam, is that correct?
Yes, Your Honor, that is correct. I did discuss with my client his right to have a preliminary examination and that the people must prove probable cause of that examination. He does wish to waive the exam and have this matter bound over to the circuit court.
Okay, so we're ready to proceed on the hearing on the violation of the bond.
Your Honor, of the violation, I would tend to agree with the defense in that and the matter of their brief. That I don't believe that would be sending a private investigator to investigate the situation would be a violation of that bond condition, Your Honor.
And Judge, if I could provide some additional background.
You said a private investigator.
I believe defense counsel did, Your Honor.
That's correct, Judge. The private investigator was retained by and hired by the defense counsel for the sole purpose of investigating a third-party witness. The private investigator did not contact the complainant, but rather contacted a third-party witness who the complainant stated in the statements in the discovery that this third party allegedly witnessed the incident. So as such, it was our duty, of course, to investigate any witnesses that may have been present at the scene. But at no time did anyone contact the complainant or direct any contact with the complainant.
Is your witness here?
She is, Your Honor.
On the stand.
Okay, I will go get her, Your Honor.
Thank you.
Just should have stepped out.
Okay, you spoke to her about this, Mr. Ring?
I have, Your Honor.
Okay, I'm looking at the police report attached to the bond violation. Says, the victim is not this person named Catalina, correct?
That's correct. The victim's name is Harley, Your Honor.
I would agree, based on the police report. Okay, 53 is dismissed. Okay, and so is there an offer on this file?
There was an offer on this file, Your Honor. That offer was to plead to count 1, the felonious assault, and count 3, domestic violence, and the people would dismiss count 2, weapons, felony, firearm. The people would agree not to add a GBH strangulation charge, and the people would consent to sentencing under HYTA.
Mr. Menzies, how are you?
Oh, yeah.
Today was the date that was set for your preliminary examination. Do you understand the purpose of that examination?
Yes, I do, Your Honor.
You understand the purpose of that examination?
I do, Your Honor.
Okay, and so you wish to waive your examination today?
Yes, sir.
You understand that waiver is unconditional. Oh, anybody promising you anything to get you to waive the examination?
Promising to get you, sorry, Judge, it's a little hard to hear.
Anybody promising you anything?
Your Honor.
Okay, if you don't hear, you can just let me know, okay? Because if you ask her, it's gonna make me think you're asking her what you should say, and then that could mean that she's the person threatening you. You see?
I
I
understand.
need to make sure she's not threatening you to waive your rights. Get it?
I understand. Your Honor.
Okay. Anybody making any threats to you to get you to waive your rights today?
No, Your Honor.
Okay, so you understand that this matter could be bound over, and then they won't have to put on any evidence today in the district court to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with a crime. You understand that?
I do, Your Honor.
And then once this matter is sent to the circuit court, you can't change your mind and decide I should have had that exam and there's not enough evidence against me. You understand that?
I do, Your Honor.
Okay. Bind over date's gonna be March 22nd. That's not a date that you need to appear in court. That's the date the circuit court gets the file from this court. Your next court date will be set and it'll be a pre-trial. You do not need to be arraigned in the circuit court on this file unless your attorney makes a special motion for another arraignment for some purpose, okay?
Thank you, Judge.
No problem. And both you and your attorney will be made aware of that next court date by the circuit court. Do you have any questions today?
I do not.
Or any additional matters for the record?
There's nothing to appeal, but I do believe the defense is going to have one question about the bond condition, Your Honor.
That's correct, Judge. As it relates to Mr. Menzies' bond, he currently does have a GPS tether with certain prohibited hot zones that are areas near where the complainant resides. Unfortunately, last week, Mr. Menzies' father died very unexpectedly. As a result, his family members have been making arrangements and have planned a celebration of life for his father for tonight. This event was not planned by Mr. Menzies himself or his mother, but it was planned by a relative who wasn't aware of Mr. Menzies' hotspot locations. It was planned for 6:30 p.m. tonight until 10 p.m. at the Garage and Fuel Restaurant. That is a restaurant that the Menzies family owns. And so that's why the family members selected this restaurant, because it's sentimental value to the Menzies family and Mr. Menzies' deceased father. Unfortunately, that restaurant is within the hot zone area where Mr. Menzies is prohibited. This was not done. It wasn't an event that was arranged, unfortunately, by my client or his grieving mother, but it was arranged by a separate family member. And they picked this location because it's his father's restaurant. So we're asking,
I'm wondering what the hot zone, what does that mean? How close is it to where the victim was?
Judge, I can look at the,
And I do have the victim here who would like to speak on that matter, Your Honor. I believe it is in dead center of the middle of that hot zone with the GPS tether.
just the hot zone is 2,000 feet.
Where is this restaurant in proximity to where she lives?
I do not personally know that.
You can ask her if she's here,
Okay.
or she can come in the courtroom.
You want me to have her just come in, Judge?
Yes.
Okay.
Raise your right hand for me. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can have a seat there. We just have a very simple question. What you said she wanted to address something about. the
Yeah,
hot
she
dog.
wanted to address
Okay, what is-
that matter before you, Judge.
Thank you. You can question her because I don't know what she wanted to share.
Ms. Hatter, can you just explain to the judge why that you would like him not to be allowed to enter that restaurant tonight?
Yes, that has been like my safe haven, just him not being able to come within a quarter mile of me has literally been the only thing keeping me sane and what makes me feel safe. Like, I don't think it's necessarily fair, and I have a lot of remorse for what happened, and obviously this is tragic, but I still don't think it's fair for him to be able to go to a restaurant just down the road at my house, let alone not just a restaurant, but a bar, and he's not supposed to consume alcohol. And
Yeah.
I just don't think that's fair. Like, that's my one place that I have that's like mine, like that he can't go to. And there's other restaurants that they are able to go to.
Thank you. Your Honor, did you have any more questions?
You said it's within a quarter mile of where you live?
Yes, it's less than a quarter mile. of where I live.
Your Honor, if I might speak on behalf of my client.
I need to give me just a minute, please. Yeah, for right now, just down. Okay, yes.
Your Honor, I just wanted the court to know that we're only asking for that specific time period of this event, and that this is an event with family only, many of whom are coming from out of town to help my client and his family with this grieving process. And also like the court to know that his family is present in the courtroom. They're well aware of the hot zones, and that they will have indicated, as well as my client, that they've indicated they will make every effort to avoid being anywhere near the complainant. And I'd also suggest that the tether itself would show if he was going anywhere near her. The point, of course, is to see his family during this difficult time. And I'd also indicate this is 1.3 miles from my client's home as well. So this wasn't a location chosen at random. It was a location chosen because it's sentimental to my client's family, as his parents are owners of the restaurant.
The prosecution will respond.
The prosecution would just leave it to the discretion of the court, Your Honor.
So the prosecution having a position.
The prosecution understands both sides, Your Honor. The prosecution understands that Ms. Hatter would not like this event to occur, but given the circumstance of it being a death in the family, the prosecution also understands the other side of this matter, Your Honor, and leave it to the discretion of the court.
The event is from 6:30 until when?
6:30 until 10 p.m.
This is a bar?
The primary purpose is a restaurant. It does serve alcohol, but the primary purpose is that it is a restaurant.
What's the name?
Garage and Fuel Bar and Grill.
The question was just, was it a bar? You said it was not.
It's my understanding the primary purpose is that it is a restaurant that also serves alcohol.
Okay, so
But
by the very essence of the name, it's a bar, correct?
I would suggest that, I think the name is Bar and Grill, Your Honor, so I would suggest that it is
Your client is on bond and he's not to have alcohol.
yes, Judge, that's
Nor is he
correct.
to possess alcohol.
That's correct, Your Honor.
So what you're requesting is for the court to amend the bond to allow him to put himself in a position where he will be in a bar where alcohol is going to be served. And then be within a 5-minute walk of the victim. And he's being charged with some very serious crimes here. There's an assault with a dangerous weapon, a felony firearms, and a domestic violence.
Yes, Judge, that is what we're asking for. I don't believe there was a condition in the original bond order that he not be permitted to go to restaurants that also serve alcohol. My client understands he cannot drink alcohol, but that is the nature of the location where his family members have chosen for this. I'd suggest once in a lifetime celebration of his father's life.
6:30 to 10 p.m. Under the circumstances, I think it's I don't know if I said it, my condolences to you and your family from the loss of your father, because I recognize that that's a tough situation to be in. And I also recognize what that does to a person. And you would want to be with your family during this time. And so I'm not going to deny you the opportunity to gather with your family. This is a restaurant that your family owns. So it's reasonable that that would have been the location whereby the celebration would be hosted. Don't see where we had, other than this P53, which the court has dismissed because it doesn't show me that there was a violation. I don't see where there's been any violations or any hits on the GPS tether. So I don't think that there's any concern or threat. Your family's here today?
Yes, sir.
Okay. Okay, so they're gonna make sure that you're at this location and then you're leaving the zone after that, correct?
Yes, sir.
You don't want to get any additional trouble with a bond violation. It's not necessary. You got too much going on. You gotta honor your father's life and you don't need to be sitting in jail for a bond violation, correct?
That is correct.
Okay, I'll amend the bond to allow you to attend your family function between 6:30 and 10 p.m. within the GPS hot zone. Following at 10:01, you got to get out of that zone. You understand?
Understood, Your Honor.
Do you have any questions?
I do not know.
Any additional matters for the rest of
That's from the field. Thank you, Your Honor.
Nothing from the defense, Your Honor. Thank you.
you?
Your Honor, if I may have a brief 5 minutes to speak with the victims.
You sure?
Thank you. Yeah. Thank you.
So Tala refused to come over. That's your guy. It seems to be a trend over there these days.
Push the issue when the guys doing.
Yep, we have that issue, yes, well, for the last 2 weeks with somebody else.
Yeah, I don't know if you got the petition from what we are requesting. See if that-
No, yeah, I'm gonna just wait for Mr. Ring to come back and I'll call that one. And looks like we have one for Elliot too. But he was brought over. treat as PCC. Does Wilson have an attorney? Do you know?
Not tonight.
Yes.
Mr. Mooks, are you leaving us?
I think so. We've done my damage here.
Didn't even see you get up in front of the court.
Sort of a half up sort of thing, you know. It was
Well, you know, he hasn't really spoken to his client, so,
she doesn't have a phone or a house.
well, I didn't say it
She
was
was
your
here last
fault.
week. She was here last week, though.
Didn't say it was your fault you didn't speak to her.
That's true.
Just saying you didn't speak to her. You waited. She didn't come. She's gonna come soon as you,
Victims either.
she's gonna come as soon as you leave. She'll be here as soon as you
That's
leave.
why I waited.
Happens every time.
Yeah, that's what I figured.
Just don't wanna go back out in the snow.
No, I'm really avoiding that at all costs.
Time changes this weekend, everybody. Get ready for spring.
Bring forward. One time. I don't care which one you pick, just pick one and stick with it.
Have a good weekend, Julie.
Have a good one. Be safe.
Thanks, you too.
It's not a dive bar. Yep. Town bond motion.
Yeah, get this moving. the record in the matter, the people of the state of Michigan versus Devon Pager, file number 22-02282, council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Cager, who's present to my right at council table.
How are you, Mr. Pager? Today's the date and the time that was set for preliminary examination. The people are moving to dismiss without prejudice. The necessary witness has failed to appear. Is that correct?
That is correct, Your Honor.
Okay, do you know what a dismissal without prejudice means for you?
Yes. It
What-
means, if we dismiss it, witness, so I can bring it up as a converted.
Absolutely. Do you have any questions at this time? Can we get you a copy of the Denali? Any additional matters for the record?
Not from the people, Your Honor.
Nothing further on behalf of Mr. Cager, Your Honor. Thank you.
You want to wait 72 hours to let us get a no contact out of Glean, okay? Yeah. Yep, you can go get that taken off. I'll wait for a copy of your dismissal though.
The delay, Your Honor. I thought Brian Rain was handling it while I was stuck in other courts.
Oh, nope, he was waiting for you. No worries, I'm still waiting for mine. And many other things.
That's about me today. I'm in almost every court, everywhere but Flores.
Oh, this was Flores isn't here.
I think he's one of those conversations.
Yeah. So. Let's see.
So Paula is also.
Your Honor, I'm going to have Mr. Lee cover my last three remaining things, which are tend to be a dismissal and two competency evaluation.
Sounds good. Thank you.
For preliminary exams.
What's going on up there? Really? We went in. I don't like these, Miss Gail.
I don't either.
I usually tend to deny them when they send me them. Am I supposed to decode them?
Well,
I don't like
years
it.
ago, we told them they weren't allowed to use that anymore, because they used to just send it as a half a page and
Right.
it was attached. Well, somehow they've started using them again.
I need an affidavit.
Mhm.
I don't like it.
I completely agree. I will let George know from GNL.
Thank you.
That is Mr. Court.
We don't be at lunch and we don't have no, you don't know what Mr. Rain's doing today. Anybody getting some coffee with Mr. Rain? Don't pass you for something, because Mr. Rain's not ready on anything. You might as well go get snacks.
I'm always into that.
Yeah.
Count me down. I just show up until you tell me you're done. If it's anything funky, I always try and leave you a note so that you know something's not.
Sparks.
I need to know who the money, you gotta check one of those two boxes. Either goes back to plaintiff attorney or return to defendant.
It's gonna go to the defendant.
I thought that was what you were doing, but I wasn't.
Yeah, I clicked the wrong box, but that's cool. That's gonna go back to Mr. Sparks, even though Mr. Cataville was upset about it. You said Odell is a Nolly.
Ring just told us.
Okay, well, everybody wants to know where their words are, so then I'll take them. I don't care that I'm doing on the bench.
Just gonna say, hand them over and I'll take them with me. Lori's been off all week, so I'm clerking for all 4 judges.
Oh, boy.
Not the first time, it won't be the last.
It happens. Oh, boy, I see we're moving along now.
Actually, I already had this. Hold on. Yeah. Yeah.
Okay, Odo. Molly. And Styles and all.
Yes.
Thank you. Thank you very much.
This is like the same exact thing. Self-contained. This is the exact same.
You're good, thanks. Working on that right now, Nick. Sheets.
Everyone's gonna really upset with me today. All these warrants. Okay. Who do we have?
This is Mr. Christie, Your Honor.
On the record in the matter of the people of the state of Michigan versus Matthew Christie, file number 23-00612. FY council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Matthew Christie. He's present to my right at council table.
How are you, Mr. Christie? I'm sorry? You're decent, okay. Today was the date. Set for preliminary examination. I have an offer here. The people are offering for you to plead guilty to an added count 2 of use of a controlled substance under MCL 333.7404(2)B. That's a misdemeanor with a maximum penalty of 1 year and or $1,000 in fines. There's no objection to sentencing under 7411, and they would move to dismiss count 1 and count 2. Do you understand that offer?
Yes.
Okay, you've considered that offer, sir?
Yes.
You want to accept it? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. Is this your signature here?
Yeah.
Did you read this? Did you read this document?
Yes.
Okay. Do you understand each of the rights that are listed here?
Yes.
Okay, you want to give up all of those rights today in order to plead guilty to use of a controlled substance? Okay, so that means that you have to give up your right to the presumption of innocence. So you understand that you're innocent until proven guilty?
Yes.
And you have to give up your right to trial. You have the right to a trial or by jury or a trial by bench, but at the time of your trial, you have the right to see, hear, or question any of the witnesses that the prosecution intended to call against you. You have the right to call your own witnesses or present evidence that you believe would further a defense to the charges. You have the right to remain silent at trial and not have silence be used against you. You have the right to have the prosecution prove each element of the charge being brought against you. They have to prove each element at trial beyond a reasonable doubt. You understand all of those rights?
Yes.
You want to waive each of them today.
Yes.
Is anybody threatening you to get you to waive your rights? Has there been any promises extended to you in exchange for you waiving your rights?
No.
Are you currently on probation, parole, or out on bond? On another matter? On another matter other than this?
No.
Okay, very good. You understand that a guilty plea can result in the conviction that you may need to report to your current employer or to a future employer. You also could have some impact on immigration or travel status that you may be seeking. You understand that? Okay. Now, didn't get enough sleep yesterday? Oh, gotta do better about that. Maybe then you can feel better when you come to court, okay? Okay. Do you have any questions about your rights? Okay, as to the added count 3, of use of a controlled substance, I you plead. Factual basis.
Your Honor, Mr. Christie, taking you back to February the 23rd of this year, where you at or near the location of Washington and Lenawee, Lansing, Michigan.
Yes.
Is that here in Ingham County? And at that date, time, and location, did you have a controlled substance on your person, specifically methamphetamine? And did you have a prescription or any type of lawful authority to be in possession of that? And was that an amount intended for personal use? Sufficient, Your Honor.
Mr. Ring,
No further questions, Your Honor. Thank you.
the court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing on May 11th at 8:30 in the morning. When you leave here, you need to go directly down to the 5th floor to our probation office so they can get you set up for your pre-sentence interview, and they'll provide the court with a report and a recommendation about how you should be sentenced, okay? Do you have any questions today? Any additional matters for the record, counsel?
Nothing we have to people. Thank you, Your Honor.
Nothing further on behalf of Mr. Christie, Your Honor. Thank you.
You're all set.
All right. Thank you, Judge.
Thank you.
Oh, wait, be down just a minute to switch out with me.
Who?
Kelly,
Oh, well, thank you.
she's just finishing up their last hearing where she's at. It was a waiver, so it won't be a long one.
Okay, sounds good.
Speaking of Kelly, we're off. I was just on the joke you were coming. I started the page for the one that is gonna run, Mr. Pager. Okay. Thank you. Thank you. Thank you.
Okay, thanks. Yeah, we're ready to go on that one. She wants to address it on the record, that's fine. So she wants to address it on the record, that's fine. Elliot? Oh, sorry, Elliot, Lucas Elliot, sorry. I thought you were saying that. No. No, okay. Lucas Elliot. Yeah, we're ready to go on that one. Seen it running out here. Yeah, I've seen him a couple times.
Thank you, sir.
It's been a long morning. I think they're still planning on, if you want to check it out, I think they're planning on running. First, boards. Yeah, I don't have nothing interesting. I don't have, we don't have anything interesting happening. It's already anything. Yeah, just had that restitution hearing that's going around this afternoon. It's not that interesting. What time is that? At 1? Yeah. Okay. So, yeah, TA. LA. I'm gonna pop over there and watch some of that one too when I'm down here. First.
Good, how are you? Yeah,
Okay.
Ready for
I'm
the
just trying to
weekend?
catch up on these warrants.
ready for the weekend?
Oh, no, I'm gonna call some.
Oh, well then, no, you're not.
I'm here.
Addie had a heck of a day yesterday typing up typing up those NGR.
Oh, yeah, she was kind of worried about it anyways, but she'll be fine. Okay, someone wasn't brought over, so we can call that one. Are you ready? On the record in the matter of the people of the state of Michigan versus Joseph Adam Siltala, file number 23-00602 FY, appearance for the record.
Brian Ring on behalf of Theo Preston, Mission Forward 8120.
Assistant Public Defender John Lee appearing on behalf of Joseph Satala.
Okay, today's the date and the time that was set for preliminary examination. The court was notified, however, that Mrs. Satala, who is in custody at the Ingham County Jail, refused to be transported, which seems to be a current theme over there. Nonetheless, you're waiving your client's appearance at this time for this purpose.
Yes, we are, Your Honor.
Okay, I have before the court a request to have the petition and referral for the defendant to be evaluated for determination as to his competency to stand trial. There was not one for criminal responsibility, was there? I don't see.
Not that I'm aware of, Your Honor.
Okay. This was signed or reviewed by you, Mr. Ring, as well. So there's no objection.
I have no objection, Your Honor.
And in short, it indicates that the defendant appears delusional and likely suffering from schizophrenia, correct?
Yes, Your Honor.
Yes, sir.
Court will grant the request and order the defendant to be evaluated for competency by the Center for Forensic Psychiatry. Case will be adjourned until the time in which we can get an evaluation or report. Any additional matters?
Nothing on behalf of you. Thank you, Your Honor.
Nothing for the defense. Thank you.
Who do we have here?
Oh, wait.
On the record, in the matters of the people of the state of Michigan versus Lucas Walt Elliott, file numbers 23-00545, and then I have 22-00393. Appearances, please.
Brian Ring on behalf of the people.
Assistant Public Defender on behalf of Lucas Elliott, who is in the courtroom and seated to my right.
You. Today was the date that was set for preliminary examination and file ended in 545, and then there was a PA 53 violation set on file number 393. That matter is scheduled for final pretrial on March 14th. However, I do have in file number 545 a request for an evaluation as to competency. Is that accurate?
Yes, Your Honor.
How are you, Mr. Elliott? Okay, in this particular matter, there is also a request for evaluation relative to criminal responsibility. Any objection?
No objection, Your Honor.
Will grant it based on the observations of Mr. Elliott's attorney, Mr. Goodrich. And so Mr. Elliott will be ordered to undergo a competency evaluation at the Center for Forensic Psychiatry, as well as evaluation as to criminal responsibility. Any additional matters today for our record?
Nothing on behalf of people, thank you, Your Honor.
Nothing for the defense. Thank you, Your Honor.
Thank you. Well said.
He's ready to go home.
Seems relatively subdued today.
Yeah.
Let's see, that was Elliot. So what's going on with, do we know where Abbott is?
I've seen him in the building, but it was earlier this morning at like 8:30. And then I haven't seen him since, but
And then we just need Wilson brought up, I guess. We will bring him, what are so many files? That's afternoon files. We are restitution hearing at 1,
yes, Your Honor. I do anticipate that running.
and then at 1:30. Ms. Lopez?
I do not anticipate that running. Word from, there was a matter with her and with the same victim at 54B yesterday. And the
Got it.
victim had COVID and couldn't appear, so I anticipate that.
Okay, that's why it says there's a request to adjourn, and then you could have got Mr. Austin a date while he was here on that one. We'll get a new date for that.
Mr. Austin's the one that informed me that the victim had COVID, was it here?
Oh, Mr. Abbott,
Ah, in the flesh.
he just sent a warrant out for you.
I apologize, Your Honor. Judge Ward is underwater today.
No,
There's a stack of.
Heard there's about 4 exams gonna run in there, and one's that CSC first.
and you're not running any of them?
I'm running 2
Well, that you're the problem, then you're 50% of the problem.
of them.
Don't drown my buddy Judge over there.
But the video is excellent.
I might come watch.
I'm gonna come watch. I'm gonna run to the
Love
office.
the video.
I'm gonna come watch.
I
Love
saw
video
this from
evidence.
my target.
Mr. Christie there.
Can't deny that.
He was gonna fall asleep at the table there.
He was definitely pretty tired. Let's see. What was I doing with this file? Lopez reset. Victim has COVID, you said?
Yes.
We'll get them a new date for that.
Yeah. Do you normally do 2 weeks?
Yeah.
Okay, I just wanted.
What is 2 weeks from now? Today is, I can't keep the days together. Let's go 3 weeks on that one, though.
31st.
Yes. Please. And then.
You want a morning or afternoon for that?
It doesn't matter.
We're already scheduled for a prelim with Miss Lopez on the 16th of March, if you want to
Oh,
set it
we
for
can
the
put
same,
it on the
if you want to
16th
set
of
it for the
March.
same day.
Perfect. We love hanging out with Ms. Lopez.
She was very informative at our
She
last.
loves to give out information.
Oh.
On the record.
Okay.
I'm like asking the witness, what's a blitz? And here goes the defendant. It's a gun. Oh, okay, thank you. Thank you. Assault with a dangerous weapon.
And then Mr. Austin was arguing that her voice was never.
Oh, yeah. But she keeps talking, so I can hear your voice, so I think that is her on the, I think that on the video, I think that is her voice. And then when I remind her of her bond conditions, you can't threaten anybody. So you mean even by phone? Yes, I mean even by phone.
Oh, we had, so we had a prelim yesterday and the gentleman at the end, we had a PA 53. Are you 4 or 3?
4.
4. At
Okay, Mrs. Johnson, who's this?
Yes, Your Honor. If I may have just a moment to refresh his recollection of our, at our last attempt at sentencing.
Agreed. Okay. So I think being agreeing on something new today. Did you tell his attorney?
No, I haven't.
Oh, he's got a new charge. I think Donnelly was just talking to him. He's supposed to be arraigned today, is my understanding.
Okay, that information.
Nelson custody? No, yeah. Wilson. Is he next?
Patrick Wilson. He was the gentleman that refused to speak.
He's got to be, he's got to examine it. Or he's going to be treated. He doesn't have an attorney, I don't think so.
Yeah, he wrote the trade at GCC.
Yeah, we'll bring him up.
Now or
Yeah, he can be brought up now. That's Rain's last one. The one on the way.
Roads are bad in that one.
They weren't too bad on the local roads. I don't know how it was on the expressway.
The expressways weren't too bad until I got closer to Lansing,
Gotcha.
and then they were starting to get slippery, and I was like, eh.
Your Honor, I think we're ready to go.
Okay, sounds good. On the record in the matter of the people of the state of Michigan versus Zachary Clyde Johnson, file number 22-02870. Council appearance.
Morning, Your Honor. John Abbott representing Zachary Johnson.
Thank you.
He's
Miss-
present, standing to my right.
Thank you. Mr. Johnson, how are you today? Okay, this matter was continued from sentencing last week. I had to discontinue the sentencing because you became very disruptive in the middle of the court proceedings. And I was unable to complete my order and judgment of sentence. I trust you're in better spirits today. Okay, so the last week, I think I was indicating to you what the recommendation was from probation. And their recommendations for you to do a term of jail time. And that's based on a number of issues. A, you're not eligible for 7411, which I think there was no objection to. But there's been a serious concern regarding your housing, transportation, substance abuse, and overall ability to comply with probation. You understand that?
No.
Okay. Well, I'm not asking that you agree with it, just that you understand what they're saying. It also indicates here that it would be beneficial for you to be screened by CAT CMH to determine what mental health services and substance abuse programs would be most appropriate. And that you need to reestablish your relationship with community mental health and receive the necessary medication. Mr. Abbott, I'll give you an opportunity to address the court further or expound on whatever was stated last week at this time.
I think it's appropriate that he gets some mental health treatment. Our argument last week, and this is the same as it was this week, that he should be allowed, like him to be allowed at least so we can establish that connection with CMH. Get that programming set up with them, as well as gain access to Social Security. And that he was outside. ask the court to suspend the balance of the jail sentence. And successful completion of those tasks.
Thank you. I think that based on the report, the defendant's criminal history, and then even his history and involvement on this particular case, there was multiple failure to appears. There was at least 2 bond violations. And then last week, my having to discontinue the hearing on his sentencing, I think is enough indication to the court that I don't believe Mr. Johnson could be trusted to handle this on his own. I think he needs some help that would require further oversight than what we could provide if we released him on a term of probation. I don't think he's a good candidate for probation. And so with that being said, I think the appropriate sentence is that which is recommended by the probation department. The sentence will be as follows. 180 days to Ingham County Jail. Last week, there was credit for 79 days, but he'll get credit for current time served. So that would bring him to 86 days. While in custody, he will be screened by CATS, CMH, for mental health and substance abuse treatment. And he can establish or reestablish his relationship with CMH while in custody. Requiring that there be no release on GPS tether. Do you have any questions today, Mr. Johnson?
Yes, I would just like to say that I do believe I could follow through with the probation.
Thank you. And that's noted. But I've made a determination that I don't believe, based on your current situation and your prior history, in this case and in others, that you would be a good candidate. As to fines and costs, it's a $75 crime victim rights fee plus $50 state minimum cost that will be assessed. I'll waive any additional fines and costs. Any additional matters for the record today?
No, thank you.
And you have 21 days from today to file an application for leave to appeal the sentence, okay? All right, you're all set.
Thank you, Your Honor.
On the record in the matter of the people of the state of Michigan versus Patrick DeMont Wilson, file number 23-00552. Counsel.
Brian Ring on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office. I do not see Mr. Wilson's name in our list of clients.
Okay, it looks like. I don't know if he ever requested at the time of his arraignment, because I don't have a note here that he can request court appointed counsel. Did you request court appointed counsel, sir?
Never had a chance.
Okay. Okay, are you requesting court appointed counsel?
Yes, ma'am.
Okay, so today was the date that was set for a preliminary examination. I put a note in here to treat it as a probable cause conference because you refused to respond to me last week when I wanted to find out if you needed an attorney. So we do have a public defender here today. What I'm going to do is find good cause to go beyond the 21-day timeline, and then you can meet with him and do an intake, and they can see if they can get you an attorney, okay? Do you have any questions today, sir?
No, ma'am.
March 31st at 1:30? 9:30, yeah.
Yeah, would that be a PC date or a PC date?
I'm gonna set, you said that as a PCC, because I want to make sure he has an attorney.
Brother, can I
It's
get
gonna
the
be
case
denied.
number again?
Yes, it's 23-00552. Thank you. We're off the record. We'll get you, or you can meet with him privately. I should probably just step out and you can do your intake in here.